Okay, good morning, everyone. I'm Brooke Dewar. I am with the Penn State Law School Center for Agricultural and Shale Law, and we are going to go ahead and proceed with what we call our quarterly dairy industry legal update. We have been doing these, or we tend to do these for the final two quarters of 2020, and then the first two quarters of 2021, and then we're most likely going to continue on, but we have that as our first four webinars. We've already completed one in this series. We did a quarterly dairy industry legal update in October, and that was for the third quarter of the calendar year 2020. This is now for the fourth quarter of the calendar year 2020. So this is October through December of 2020. Our next one will be in April, and then we have one scheduled for July. We're working on trying to build up our attendance and the desire. And if you have input that you'd like to give us on these, we certainly welcome that, and we welcome input on topics, formatting, anything that you would like to give us some input on. That's fine, and you can just email me. My email address will be coming up later, and the PowerPoint slides will be available so you can get it from those. Again, this is the quarterly dairy legal update series, and we are again in the second of four. The first that we did in October is available for viewing from our website, and most of the slides here that I use today are going to have links, and many links in them. If you click on, hopefully you can see my cursor. If you click here, you're going to be able to watch the first in the series. The materials, in other words, this PowerPoint, is available by clicking here to go to our website. Now, it may not be loaded up there right this minute, but it will be loaded up there very, very shortly after this is over. So I'll probably be referring to the links many times, and I think I make these PowerPoints specifically so that you get them and use the links because it's really, I find, to be invaluable. All right, a couple of preliminaries. Here's our agenda. What we're going to do and what we did the last time, and in this series, we are going to do a roundup first, which will be essentially a review of the past quarter's legal and regulatory developments that impact the dairy industry. And then we'll go to a section that we're just calling sort of the focused topic. And hopefully we've hit some topics that are of interest to dairy producers and professionals in the ag industry. The focus topic for today is dairy exports and trade agreements. And we have a guest, and we've had a guest and tend to have a guest for all of these. Becky Rasdall is our guest today. She is the Vice President of Trade Policy and International Affairs for IDFA, International Dairy Foods Association. And Becky has a very interesting job history, which she will tell us about. It ended up, because IDFA is having their annual conference right now as we speak, I had to record my interview with her on tape, essentially, and then we will play that. So we can't have question and answers with Becky, but that was the only way I could arrange for her to, to be involved. And I think she does bring some very good experiences and a very worthwhile guest here for our purposes. Before getting started, we want to thank the people that bring this to you, which is we operate under several sources of funding, one of which is a grant from the United States Department of Agriculture National Agriculture Library. And that is given to us through the National Agricultural Law Center, which is at the University of Arkansas. So those are our sponsors here, and we want to thank them for bringing this programming and making it possible. Little shameless self-promotion here. Of course, we are the Center for Agricultural and Shale Law at the Penn State Law School. Beautiful picture of the law school. Doesn't look like that right now, obviously. The links to, this is our website, and I'll show you something about that in a minute. We have a brand new website This is our Twitter page, and this is our Facebook account. We actively use Twitter and Facebook on a daily basis, and it's a great way to get agricultural news. This is our brand new website. It's literally a week or two old in terms of being currently in use. We're stocking it full of all sorts of good things and retooled and redesigned things. So here's a link to it. You see across the top, there are a bunch of drop-down tabs here across the top, and all of our publications, podcasts, videos of events like this are all in these drop-downs, very easily accessible. The events tab is where today's event is listed. That's where you'd go to get the materials. Publications are the things that we publish. Research by topic are some things that we do, like a virtual resource rooms on particular topics where you can just read up on things and do research, as well as a new product that we've been putting out, and we have a handful of them now with more to come shortly, which are called trackers, which is taking a particular issue and then essentially putting all the developments in that issue in chronological order with links to all of the primary source documents. So it takes an issue hopefully from a nice starting point all the way through and gives you all of the primary source documents on that particular issue. Watch or listen. Listen is where you can see videos of things like this webinar, as well as hear our podcasts. Mediation is about our mediation program, which I'll talk about in a second. And the legal clinic tab is for what's called the Rural Economic Development Clinic, which is a clinical program for law students to do legal work under the supervision of the 3 attorneys here that are in Pennsylvania that work for the center, myself, Ross Pfeiffer, and Jackie Schweikler. This is our new way to receive or to read our agricultural law weekly review. Many of you may get that by an email distribution system. That will continue, of course, but you can go here and look at them and see the old ones in a much easier format than used to be the case. And you can subscribe by clicking on various links over here on the right. And then here's some boxes that'll take you to our podcasts. Our YouTube channel is in fact where all the videos get stored. So this is how our weekly review is going to look from now on, very nicely improved in terms of the visuals and the readability. And it'll all be right in our website, which it was not before. Also, of course, our podcasts, I think they're getting better and better. Of course, I do the ag podcast along with one of our excellent research assistants. So I know some people are not podcast people, neither was I when I started here, but I find it to be quite an eye-opening experience to do them, and I think that they're well worth the listen. The agricultural mediation program is a program that at one point PDA was doing, and it's a USDA funded program. Used to be just for USDA related programming disputes, and they would be mediated with the USDA. But now, and I've marked it in green, be very aware that there are non-USDA issues that can now be mediated through the agricultural mediation program. And so all sorts of things that would be the normal run-of-the-mill kind of things like lease disputes, boundary disputes, all sorts of things that would be commonplace for ag clients can be handled through the Pennsylvania agricultural mediation program. Jackie Schweikler, one of our attorneys, is in charge of that program, and here is all of her contact information. Again, you can get a copy of this PowerPoint, and all these links will be usable for you to get right into that. Now, in terms of housekeeping for today's webinar, the webinar is being recorded. Just obviously need to inform you of that to the extent that you may wish to go on microphone. And I think we have a raised hand function here. Maybe we don't. The webinar will in fact be posted on our website under the Watch and Listen tab as soon as we're able to get that up. There is CLE credits available for this event, 1 hour, And the way you do that is the forms can be obtained and completed and submitted really online. You go to our center's website under the events tab, and the event for the tab for this particular event, and I have a link to it right here, and that will give you the further links to fill out the form. Part of the process of submitting or obtaining the CLE credits is that we have to verify compliance in some way. So we have to give you some type of way of checking up on you to make sure you didn't, run out to the store or jump in the shower. So the idea is that we give you some codes through the course of it, 2 of them, and then you hopefully you then have those and can fill out the form. They are required on the attendance form. So the first code is right now. At 2:13, we're going to give you the first code, which is milk. So there you go. You got your first code. We'll give you the other one later on in the programming. If you check the chat, there is information on receiving the CLE credits. Again, here, Jackie Schweikler has just posted that. And so that, got ahead of myself. Oh, where are we? Okay, right there. And so there you go. That's how you get your CLE credits for today's webinar. We intend to keep doing these. Okay, let's get right into it. All right, the roundup of dairy developments for the last quarter. I'm going to start off with the one that organized this webinar in terms of what we were going to cover, which is trade. And the dairy industry has the, maybe it's not an honor, but has the obligation at this point that it has become the first area of dispute with the USMCA, the United States, Mexico, and Canada trade agreement that was just executed last year. And this is the very first dispute. And the U.S. Trade Representative on December 9 sent what is called a consultation request to the Canada Ministry of Small Business, Export Promotion, and International Trade. And the letter is available by clicking on this link, and you can read the what's basically been stated. These request letters are public, but then what follows after them is not being treated as public. So at this point in time, a response was due from Canada to this consultation request, and I presume it's been submitted. There's been no publicity about it being submitted or its contents. And I believe that is because they're treating these as confidential. But we presume at this point that negotiations are now ongoing. Now, the subject of this dispute, the two main, I would put it this way, there's only one subject of dispute, but there were two main issues of compliance with the portion of the USMCA that dealt with Canada and dairy. And the first was this issue of having some classes of dairy products in their pricing scheme that did not really match up with US class pricing. And this was primarily in the dry products and the powders that Canada had some price classes that seem to be duplicative or susceptible to being used in a way that was hampering U.S. sales of those particular products into Canada. That, at this point, the jury is still out, and you will hear our guests talk about that a little later on, as to whether Canada has fully complied with the spirit of the agreement, if not the letter of the agreement, with regard to those price classes. So we are not out of the woods on that particular issue, except it is not part of this particular dispute. This particular dispute is about what are called the dairy tariff rate quotas, TRQs. And what that is a certain category of product that can be sold into Canada at reduced tariff rates, and certain customers, I guess we'll call them customers, certain customers on the Canadian side can purchase these products at a reduced tariff rate. Now, what's happened up to a certain quantity. Now, what's happened and what the complaint is essentially that by Canada's limiting of large majorities of those dairy rate quotas to only being able to be purchased on the Canadian side by what they're calling processors or further processors, they are essentially hampering U.S. ability to export products because the customers that they have allowed to buy these products at these reduced rates aren't interested in those products. For example, and you'll hear it discussed when Becky Rasdall talks, that butter is the example she uses. For example, those that can purchase U.S. butter at this favorable rate, which is, hopefully then making U.S. products able to be exported into Canada at a favorable rate. Those people are processors. They have their own butter. They're not interested in buying U.S. butter. So that's probably the best way to just say it in stark terms. So what's happening is by manipulating, perhaps is the allegation, by manipulating who can purchase at these reduced tariff rates what products, essentially it's a blanket discouragement of any ability of the U.S. to import those products into Canada because those customers aren't interested in those products. They don't need those particular products. Retail is not eligible to qualify for these reduced tariff rate on particular products. So, and that is what the U.S. exporters want to sell into Canada. They want to sell to retail chains, not to processors. Processors don't eat their products. They got their own. And so that may be a bit of an oversimplification, but that's the nuts and bolts of it. And so we're going to presume that that is going to be the subject of negotiations for the next several months. Probably the important thing also, which we'll discuss later, is that this is not under the WTO dispute resolution process. This is under the specific dispute resolution process that is contained in the USMCA. People may be aware the WTO is a little bit non-functional right now or non-functional as a dispute resolver because the United States has failed to appoint people, judges, they're termed, has failed to appoint judges to essentially oversee and conduct the dispute resolution process. So this is internal processes that are in the USMCA. Okay, I will try to continue and go as quickly as possible. Gotta watch my time. All right, the second so I guess back to the Canadian dispute for 1 second. I think what we're looking at here is, an issue that's going to continue to proceed through the calendar year 2021. Perhaps we will hear something that will be publicly available later this year as to where the two parties are on this particular negotiation. Obviously, it's an odd circumstance to be involved in a trade dispute with our closest neighbor. So not perhaps what people expected when the USMCA was first signed, but certainly was an area of intense scrutiny when it was being negotiated. So it was certainly a driving force. Everybody was interested in this, in exports into Canada being more potentially more favorable for U.S. Processors. Let's go to the next. The next big issue, of course, was the Dean Foods bankruptcy. And to just simplify it down, bankruptcy court, I jumped ahead. Bankruptcy court has a 90-day window before, in the 90 days before the filing of a bankruptcy petition, where the trustee who is in charge of the bankruptcy estate, or actually in this particular case, it's actually, I believe, the unsecured creditors committee who is controlling the shots with regard to this particular issue. They're allowed to look back in that 90-day window and attempt to recoup payments that were made by the debtor, the bankrupt party, that may have been outside of the normal course of business. And the idea is to try to smoke out instances where there may have been preferences, and that's what they're called, preferences to certain creditors over other creditors when they're all basically of equal rank and they're all just unsecured creditors. The theory behind it all is that they should all be as close to in the same boat as possible, because generally they're the ones who are getting pennies or nickels on the dollar. So the idea is to sort of provide some authority for the bankruptcy estate to go out and grab some money back, claw back funds that may have been paid in a manner that was unfair to other unsecured creditors. Some of it has to do with the idea of insider, but that's not actually the provision they're working under in this case. In any event, strangely enough, the independent producers who were selling to various Dean plants across the country got caught up in this net when the accountants looked at the numbers without any knowledge of the dairy industry and said, wow, look at all these payments to these all of these dairy producers within the 90-day window. We're going to sue them all to get all that money back. And look how much money we'll have for the benefit of all the unsecured creditors. Well, that was obviously the viewpoint of those who knew nothing about the dairy industry. These were all payments that were, of course, in accordance with the normal course of business. In fact, they're legally required by state and federal law, and state law in many, many, many states, including Pennsylvania, but federal law for sure. And so that was obviously an unfortunate use of what's called the preference power, or the power to recoup preference payments, and it absolutely came out of the blue. And as far as I'm aware, it's the only use of the preference process, and sometimes they call these things avoidance claims. It was the only use that I'm aware of that anyone could recite in this instance, and it's mostly, I think, because people looked a little closer before they fired off these claims. So what happened is this lawsuit, or this law firm in St. Paul, Minnesota, dashed off these hundreds and hundreds of letters to all these dairy farmers saying, you owe money back to the bankruptcy estate, pay up. And they gave them they gave them this minuscule window of time between November 24th was the earliest date of a letter, that these demand letters that I know of, and I think it was December 15 they were to respond by, saying, pay this money back, or at least give us all this information about these payments, or else we're going to sue you the day after Christmas, was what they were basically saying. And so the bottom line is, it obviously sent everybody scurrying to try to figure out what the heck was going on. And that certainly was an earth-shattering event in its own way. And those who know the law and know the dairy industry may have been comfortable with the idea that somehow this is going to get worked out, because it seems to be a misuse of the section of the bankruptcy code dealing with preferences. But I'm sure that the dairy farmers who got these letters did not think so. And sometimes these were not just thousands of dollars, they could be hundreds of thousands of dollars, depending on the volume of milk that you're selling to Dean Foods. Again, my slides are long, detailed explanations of these issues. They're there mostly to be read, not for me to sit here and read them to you. Obviously, most of you are probably aware, American Farm Bureau Farm Bureau Federation was immediately on the stick and fired off a lengthy letter that was dated December 4. And that letter basically excoriated this law firm for doing this without understanding what they were getting into. And quite an interesting read, quite exhaustive, and better explanation of what was wrong with what they did than anybody else could write. So that put everybody in a bit of a tizzy for a while there. And hats off to our Pennsylvania Milk Marketing Board, because the Milk Marketing Board was immediately on it. And I know that perhaps we might even have one of their legal counsel on the phone here. I know he registered. And hats off to them, because they got immediately on this. And in cooperation with the Pennsylvania Attorney General's office, they negotiated with the law firm, pointed them, sort of straightened them out, pointed them in the right direction, and said, you have to provide some method for dairy farmers to show you that these were completely normal payments in the normal course of business, and they are not preference payments as the bankruptcy code contemplates them. And these people should never be made to spend thousands of dollars on attorneys to prove to you what you should have known before you ever sent out these demand packages. And it worked amazingly. The law firm agreed to back off, and not just on behalf of all of the dairy producers that got these letters in Pennsylvania, but everywhere in the country. The forms that were prepared by the Pennsylvania Milk Marketing Board to be used by dairy producers to send back to this law firm to illustrate to them that these were not preference payments were immediately put up on the Milk Marketing Board's website. Those forms could be used by any dairy producer in the country. The law firm agreed to accept that information and hold off, provided that they got it in a timely manner. And there were some there was not an ironclad deadline, but there was a window that they wanted to get them in, certainly by the beginning of January. And then the law firm was indicating that they would take them to the Unsecured Creditors Committee and negotiate a forbearance and/or a complete withdrawal of any type of preference claim. So that entire process is now just churning through the system. And most of the discussions at this point are in the nature of settlement discussions. I'm not the one to give out any public information. Perhaps at some point we may hear an update from the Pennsylvania Milk Marketing Board, perhaps not. Perhaps we'll get an update from the Attorney General's office someday, or perhaps from the law firm from St. Paul. Welcome any input from our attendees. If someone has the latest word from the law firm in St. Paul as to what is going on with the documentation that they have in hand. But again, kudos to the Pennsylvania Milk Marketing Board for setting up a process whereby dairy farmers did not have to incur thousands of dollars of legal fees to have this fight that shouldn't be going on in the first place. And this was essentially for the benefit of all 50 states or whoever was selling to Dean plants. I doubt that anybody in Alaska or Hawaii were selling to them, but so that was quite a development for the month. Those two alone are quite significant developments for the month. Another significant development, it just so happens to also be from the Pennsylvania Milk Marketing Board, is the fact that after a number of years of administrative litigation in front of the Milk Marketing Board, at the beginning of December, they entered an order that added a 24 cents per hundredweight additional cost reimbursement that would go to those who are co-op members and would go to their cooperative, who of course does all the paperwork on their behalf, for milk that was purchased from cooperatives. And the theory is that this was a fair representation of the cost savings that milk dealers or processors were realizing every time they purchased a hundredweight of milk from a cooperative and its members, for savings for things that they did not have to incur, or costs they did not have to incur, like field work and laboratory work and producer payrolls and invoicing and dispatch and logistics. And so all these things and services that the cooperative brings to its members that the dealer, the milk processor, does not have to perform when they purchase from a cooperative were finally accounted for in a pricing system, as Pennsylvania has. Of course, not all states have a thing like this where the cooperatives services are recognized in this way, but Pennsylvania looks to be the first state that has recognized these services formally and provided compensation for them. So it's pretty groundbreaking in terms of the recognition and acknowledgement of the services that a cooperative is bringing that enable a processor to essentially save money when they buy cooperative milk. They don't need the overhead of what they otherwise have to carry whenever they're purchasing from a slate of independents. So it was probably the most important part of it, although it's obviously an economic benefit to cooperative members. It's also the theoretical and the conceptual breakthrough, perhaps is the way to say it, that this represents is quite important. And it's something that should get Pennsylvania noticed as a state that has emerged perhaps from a time when the benefits that cooperatives were bringing that benefited processors were not being recognized. Or they were hard to articulate and easily discounted, perhaps is one way to say it. So it was a pretty big victory there and quite a conceptual transformation that now on the books in Pennsylvania, we have this cooperative cost recovery in our formal state milk pricing system. By the way, if you have questions, I don't think I said this before, we prefer that you put them in the Q&A rather than in the chat because it's easier to keep track of them in the Q&A. Okay, next thing is another Pennsylvania item, and I don't mean to be concentrating all on Pennsylvania items because we do like this to be a multi-state and a national interest webinar series, but we have some certainly a concentration here. We have some issues that Pennsylvania used some of its CARES Act funding to create a dairy indemnity program for those producers that essentially either took a hit or took a loss on milk or had to dump milk due to the market interruptions from COVID-19. $15 million was set aside by the Pennsylvania legislature in the budget, the appropriations bills that were passed in July of 2020, which some of us would refer to those as the 5/12 budget, covering the first 5 months of the year. And in that budget was this $15 million of CARES Act money to provide indemnity to dairy farmers who had milk market disruptions, we'll just say. So we learned in November that 7.6 million of that $15 million was spent to reimburse dairy farmers for losses. There was a balance. So the full $15 million was generous and was also more than was needed. So the balance went to the Pennsylvania Department of Corrections. And it was a good success story in terms of the use of CARES Act funding to do exactly what presumably we'll say the U.S. Congress intended it to be used for, these types of things at a state's discretion. So Pennsylvania used theirs for this, and it worked. 7.6 million of it was utilized to assist dairy farmers who were suffering losses. And the rest of it was used for the Pennsylvania Department of Corrections once the program concluded. And I believe that the statutory deadline for concluding the whole thing was November 30th, I think, or maybe it was, I think that's when everything had to be spent. So that's why the 5/12 budget came. Actually, I should correct that. In the 7/12 budget, the budget that was for the last 7 months of this year, of the state fiscal year 2021, in the 7/12 budget, the balance was sent to the Department of Corrections. So between those two budgets, the program was created, and then the program was essentially dissolved. But in the meantime, it gave out $7.6 million to Pennsylvania's dairy farmers. Many other states had similar uses of their CARES Act money. This was just one example. I know Delaware had, or Maryland had a particular use that they made with some of the CARES Act money that I have read about. Other states have done different ag-centric programs with CARES Act money. This just happened to be Pennsylvania's. Hats off to the legislature and the Pennsylvania Department of Ag, who wrestled with this entire thing to try to get this right. There was not without its kinks, but everybody worked it out eventually, and the program was stood up and then closed. Let's talk about CFAP 1 and 2, big issues that have continued chugging on through the last quarter of 2020. This couple of slides that I have here for CFAP 1 and 2 talk about the how much money was spent, and so I'm gonna go ahead because I realize we're really running late on time. This slide gives you CFAP 1's total expenditures. It also gives you where dairy fits in, which is the light green, where dairy fits in the scheme of things in terms of dairy versus other commodities, and also gives you what states received what amounts for dairy in CFAP 1. CFAP 2, of course, was the one that followed, and this again gives you the same thing. Note the same total. You see dairy is a much less percentage of the whole, and as a commodity, other commodities were added in to CFAP 2, and so dairy, while on its percentage of the whole is less, I think the dollar value isn't all that much less, a little bit. Interesting little issue over here, which is Michigan and Pennsylvania. If you study the numbers, Michigan did not get its act together to apply and utilize CFAP 2 monies very well, and then they just exploded in CFAP 1 monies. And Michigan and Pennsylvania was ahead of Michigan in terms of gross receipts under CFAP 1. CFAP 2, if you look here, Michigan just smoked Pennsylvania in terms of the amount of money that was being utilized. Pennsylvania's utilization of CFAP 2 really fell off. Just means that for whatever reason, which probably is worth studying at some point, Pennsylvania dairy farmers did not utilize CFAP 2 and maybe it's because markets were better. All right. In addition to the we are right now sitting on an appropriation of $11.2 billion for more CFAP, essentially, and more coronavirus food assistance program. I think it's program. 11.2 billion in the most recent, 2021 Appropriations Act, but we have no mechanism in place to push that money out. So that's a Biden administration thing. USDA also purchased or is set to purchase about $60 million worth of food under what they call these Section 32 purchases, and also the Farm to Families Food Box Program right now is just getting underway with its 5th round of $1.5 billion of aid to the dairy industry. Of course, that's added to many billions previously. I think the Farm to Families Food Box Program, which includes dairy, but of course not specific to dairy, is probably approaching 10 billion at this point, maybe, or somewhere in that ballpark. Some miscellaneous other issues. I probably ought to go right to our guest here. I'm notorious for going long, so I have to apologize for that. There's a couple of other developments here that I think are worth reading. There was a report on the China trade agreement, not real conclusive as to anything specific to dairy, but I wanted to include it here anyway. There was an it's called the International Dairy Federation, published a clarification of dairy terminology that they're going to utilize, and hopefully that sets some standards and basically leads the way overseas to essentially define milk as essentially I'll put it this way, excluding the plant-based milks from the definition of milk, or from the those substances that are permitted to use the term milk. How's that for getting around the issue? All right. Okay. Thank you for anyone who's still hanging in there. Your loyal listeners and troopers to hang in there that long. My fault. I am a bit long-winded. So thank you. If you need any more assistance with regard to the CLE forms, Jackie Schweikler is probably the best person to contact. Again, it's all under our events tab on our website. And again, contact Jackie at our center if you have any questions about any of it. And again, our code words were milk and regulation. Thanks. Good afternoon, everyone.